Yes, one second. I'll just take out my specs. Like, isn't it? Take it out. Yes.
May it please, Your Lordship, like to mention urgent listing of three matters.
Three matters.
Yeah, criminal religion petition, criminal petition, and AB.
When do you want?
Day
Next
after
week?
Tomorrow.
Tomorrow?
Day after tomorrow.
Okay, Wednesday.
Your Lordship, I also want to mention item number 26, 27, and 28.
27, 26, 27, 28.
Yes.
Case diaries are not there.
Not there, no.
All the three matters. Okay. Heard Mr.
Kachopi, appearing for Tison.
Appearing for Ms. T. Som, learned counsel for the petitioner, and Ms. S.H. Vora, learned APP for the state. Ms. S.H. Vora submits that the case diary is not available, and as such, she has prayed for some time to place the same. Prayer is allowed. List this matter on. When can you bring it? This is,
Lordship, can it be on 24th of August?
24th of August is okay? Okay, 24th of August.
All three matters, Lordship.
Today is what? Today is 10th.
10th.
Okay, all three matters, right?
Mention item number 30, Your Lordship.
30.
Yes, Your Lordship.
What happened?
Not there.
Huh?
CD is not there.
CD is not there, Miss Bora? Okay, heard Miss Smith,
B. Soren.
B. Soren, London counsel for the petitioner, and Miss Acadia, S.H. Bora. S.H. Bora submit that it is not available. List this matter on.
25th, Lordship.
My senior one here, out of station.
So,
So on
Any day?
27th, petitioner is on interim, Lordship.
okay, petitioner in interim. So 27th?
No.
Or interim order passed early shall continue until the next returnable date.
On behalf of item number 22.
আচ্ছা এই ফেনখন বন্ধ কৰি দিয়াচোন, I cannot hear them. নহলে এই sound টো আহি আছে. Yes.
CD is not.
Which one?
Item 22.
22. Okay. 22. Case diary is not there, Miss Bora?
It's not there, Lordship.
Okay. Heard, Miss?
In behalf of KDP.
Okay. Your name, please?
Simashri Talukdar.
Shrimashri Talukdar, appearing on behalf of Mrs. K. Devi, learned counsel for the petitioner, and S.H. Bora, K. Devi.
Interim
S.H. Bora.
NDP.
Yes, interim is there.
Yes, Lordship.
Interim order passed early shall continue.
On
Oh,
28/08.
Oh. Okay. তোমার এই হেৰি পা আহা নাই. Yes.
28.
28, huh?
May I please, Your Lordship? I beg to mention item number 31 of supplementary list.
31 of supplementary, okay. Where is that 31? Wait, there's no 31 here. 1 and 2 of supplementary.
CD is available. That is in daily list.
Oh, it's not supplementary, main
It's
list.
in the daily list.
31, CD is not there.
CD is available.
CD is available.
Yes, Lordship. Due to personal difficulties, the conducting council will not be paid for today.
Okay.
Lordship.
Okay, fine. We will retain the CD till the next date. So when can you do it?
Any day, Lordship.
Okay, day after tomorrow?
Yes.
So whom are you appearing for?
PP Pothabur.
PP Bhattakur. Okay, Mr. Your name?
A Goswami.
A. Goswami, learned counsel. Your name is there. Heard Mr. A. Goswami, learned counsel for the petitioner, and Mr. S.H. Bora. Mr. Goswami submits that the conducting counsel is indisposed and has prayed for some time. Prayer is allowed. However, Ms. S.H. Bora submits that the case diary is available. As such, it is directed that the case diary be retained till the next date. List this matter on 12th of August.
Lordship, interim order maybe.
Okay, interim order passed earlier. There is interim. This is AB.
AB, Lordship.
This is AB. So we will. Says there is. Okay, interim order passed earlier. Shall continue. Yes. 1 second, wait.
Here is made a
Mm.
already charge sheet has been filed in that.
Mm.
And where I have been shown as the apps phone number.
Mm.
That's why I'm apprehending.
What is the offense?
376 is the other. 370.
And 506,
My lord.
scan copy of TCR may be.
Can we come to the FIR, my lord?
Let's see. Where is the FIR?
FIR at page number 9. See what happened? I was supposed to, our marriage was, my marriage with the ex-woman was fixed, man. And in between, I came to know that she is having affair with another body.
Acha.
So I declined to marry her. So, thereafter, we said,
Acha, let me see. Madhav Modak.
page number 9.
Okay, I'll read it myself. Okay, let him be on bail. Heard Mr. Ali, H. Ali, learned counsel for the petitioner, and Ms. S.H. Burman, S.H. Bora, learned APP for the state. By this application, the petitioner has prayed for bail in connection with PRC case number, PRC's case, right? PRC number 117 of 2024, registered under section 417, 376, 506 of the IPC, arising out of Dhubri PS case number 1293 of 2021, pending before the learned Chief Judicial Magistrate Dhubri. This is AB, right? Yes. Oh, pre-arrest bill, huh? Paying for pre-arrest. But the FIR, in connection with which the petitioner has apprehended arrest, was lodged by the victim, alleged victim, was lodged by the alleged victim on 10th of August 2021 before the officer in charge of Dhubri Police Station, Dhubri, stating inter alia that since 2.5 years, the petitioner, the petitioner was having a love relationship with the informant, and that marriage was also fixed between them around 1.5 years back. Full stop. The informant further stated that since then, good relationship developed between the informant and the petitioner, and that both the parties used to enter into sexual intercourse between them, amongst them. Full stop. It is further stated that that one day, that is on, it is further stated that on 8/8/2021, the petitioner called the informant over phone and threatened her that he'll not be able to marry her, and that he would beat her if she insists him to marry her. And that since that day, there was no communication between them. The police, on completion of the investigation, submitted charge sheet.
Page 14.
So him as
Page 14.
absconder also.
Submitted charge sheet on 30/10/2023 against the petitioner, against only the petitioner, against the petitioner.
Yes.
Thereafter, trial started.
Yes, madam, I have received someone.
You have received summons. Charges are framed.
Cognizance has been taken, Lord.
Yet to appear, madam.
Acha. So, the learned counsel for the petitioner submits that the petitioner and the petitioner and the victim were supposed to get married, and their marriage was also fixed. But due to some other reasons, due to the reason that the informant had relationship with someone else, the petitioner had refused to marry her. And as such, as a retaliatory effect, the informant lodged the instant FIR. He further submits that although the petitioner was shown as an absconder in the charge sheet, but the petitioner had never received any no, but the police personnel had never visited the house of the petitioner. He submits that the petitioner had received summons from the Court of Chief Judicial Magistrate Dhubri for appearance. Ms. S.H. Bora, learned APP for the state, submits that allegations are present in the FIR to the effect that the petitioner had refused to marry the informant after having physical relationship with her. And as such, he submits the ingredients of cheating and section 376 IPC is apparent in the instant case. Upon consideration of the submissions made by the learned counsels and on perusal of the contents of the FIR as well as the charge sheet, which shows that the physical relationship between which shows that the marriage between the petitioner and the victim was fixed and both the parties were having physical relationship on their own volition. This court deems fit, continuation of our sentence to, this court deems fit to release enlarge the petitioner on pre-arrest bail on furnishing of a bail bond of rupees 20,000 with one local surety of the like amount to the satisfaction of CJM Dhubri under the following conditions. Petitioner will not approach the informant at any point of time. Petitioner will not influence the witnesses connected with the case. Petitioner will not tamper with the evidence collected in the case. Petitioner will not leave the place of residence without the permission of CJM Dhubri. Petition is disposed of. It will, if it were violation of any of the conditions, will result in cancellation of the bill. Huh?
Item 3.
Yes, Mr. Pathak.
Application for anticipatory bail matter.
Acha, what is this matter? Item number?
Item number 3, ma'am.
Okay.
Application in the FIR is that certain depositors of a cooperative bank had lost an FIR saying that the deposits have been placed in certain investments contrary to the directions of the RBI. The investments have failed. And because of that,
So where is the FIR?
My lord, the FIR, your lordship will find at page number, starts at page number 16.
It's a long FIR.
Not very long, madam.
16.
Page number 16.
Okay. What is her name?
She is the accused number 5.
5.
Though she has been named as Mitali Das, she is actually Mitali Thakuria.
Okay.
There was a mistake in the name, but it's the same.
Mitali Thakuria.
Thakuria.
Okay. Alias Mitali Das.
Fine.
Okay, I'll just go through the FIR in a nutshell.
Like your lordship had the occasion to deal with a couple of connected matters. I'll just go through the FIR. That the accused number 1 so and so is the founder and president of so and so, and while serving as president, started from was also in the bank.
Okay, I'll read it myself, Mr. Pathak. I'll read it myself. So main allegation is against the president.
President.
And where is your name in the contents of the FIR?
In the context, I
Nowhere.
have not.
Okay, only
was-
that accused persons.
I was the cashier in that bank.
Mm. Yes,
Is the
miss.
cashier in the state bank lordship, because lordship allegation must be there. So lordship is involvement.
Then yes, it is a Samavaya Samiti.
Yes,
I know.
And there must be a account in the name of the Samiti in the bank.
I know.
yes.
So individuals cannot do anything. Right.
President and the
But what is the
secretary.
role of the?
And moreover, president is the main alleged wrongdoer or
They
whatever.
have the common and dishonest intention to utilize the collected money
Yes, this is
from
what
the
is
public,
stated.
the misappropriation of public money.
She is a lady, let her be on bail.
President and secretary have also been granted privilege of
Oh,
bail.
so-
Orders are there.
So public money lordship is also
Hmm.
involved with the alleged crime.
Similar privilege is
Mm.
granted on similar conditions. And
Okay. Third, Mr. KP Pathak, how is your father?
Little critical.
I'll go and visit. Third, Mr. KP Pathak, learned counsel for the petitioner, and Ms. Asaj Bora, learned APP for the state. By this application, the petitioner has prayed for pre-arrest bail in connection with Polashbari Police Station case number 171 of 2026, registered on 21/7/2026 under sections 61 2, 318 4, 316 5 of the BNS 2023. The FIR in connection with which the petitioner is apprehending arrest was lodged by the informants stating inter alia that they are the regular depositors in the Khudra, Khudra Sanchay, SANCHAY, MINE mini bank, within bracket, small savings mini bank, operated by Rani Bholagaon, Gaon Panchayat, Samavaya Samiti Limited. Are you spelling too? Simple. Full stop. Oh, they were the so and so. And that they had deposited money in various savings and security deposits in the said Samavaya Samiti, of which the accused number one is the founder and president. Full stop. They further stated that the said mini bank was functioning without complying with the directions of the Reserve Bank of India and in violations of the rules and regulations applicable to the cooperative societies under the government of Assam. Full stop. They further alleged that the money that they had deposited were misappropriated by the members of the said committee. The learned counsel for the petitioner submits that the petitioner is the accused number 5, arrayed as such in the said FIR. And that the petitioner was working as the cashier of the said committee. But he submits that the petitioner has no relation whatsoever with the offense alleged by the informants. He further submits that other accused persons were also enlarged on bail. On the other hand, Ms. S.H. Bora, learned APP for the state, submits that the allegations are apparent that money was taken from the depositors, which were neither returned nor any profits were given to them. Rather, there is allegation that it was misappropriated by the members of the committee. Upon consideration, upon consideration of the submissions made by the learned counsels of both the parties, and more so, looking at the facts of the case, wherein it can be discerned that the money was deposited in the account of the summity and the petitioner is not capable of misappropriating the same. This court, this court finds it fit to enlarge the petitioner on pre-arrest bail on furnishing of same. Petition is disposed of. Okay. Thank you. Case diary is there. Or scan copy. Okay, we will take it up after some time because this bench was supposed to sit late. No. Opposite Madhima. After some time. You are there? Or councils will come late?
My senior is coming in the passport.
Lordship, CD is not available here, Lordship.
So CD is not available. He was enlarged on interim pre-arrest bail.
Yes, Lordship.
So let it be extended. Okay.
April 21. This one not a pending.
Acha, pre-arrest bail of other co-accused were cancelled. Were rejected, right?
Lordship, Lordship, kindly give us a date. So another date, Lordship. On 26.
But then this was supposed to be before the appropriate bench.
Yes, otherwise.
The honorable judge who had rejected their bail
Yes.
applications.
Yes.
Who had rejected? Mr. P. Das had said this. Miss P. Das. Priyanki Das? No. There are a lot of P. Das. Okay.
It was earlier came on 3/2/2026. Lordship.
3 to 26, it was then also I don't think so. Case diary was not there.
Yes. Lordship.
Now, in that order, it was reflected that the other co-accused's interim bail was rejected by
No.
another bench.
Lordship.
So it was supposed to be listed before that.
Yes.
I don't know. Let's see if there is any office note. There is no office note. It was in fact throughout me. As far as this case is concerned, it was throughout me. But the cases which were rejected by the
Some other bench.
some other bench.
Yes.
So, what?
Let the matter be listed.
After, let me see later.
Yes, Lordship.
Okay, heard, miss. Your name, please.
Passion.
G. Kashyap, learned counsel for the petitioner, and Miss S.H. Bora, learned APP for the state. Miss Bora had submitted that the case diary is not available and has prayed for some time for placing the same. Prayer is allowed. List this matter on
25th of August.
25th of August 2026. Interim order passed earlier shall continue until the next returnable date. On the last date, interim was not continued.
23, Lordship, wrong scan copy has been received. by
Mhm.
Post Office.
The councils are also not here. So let us go serially, right? Mr. Biswas, you are waiting for which matter? 36. Okay. 36 to matter. আর serially যাও এবং নাই আমার
Lordship, 23 wrong CD, wrong TCR has been received by the registry. Lordship.
Okay, let the council come. We will take it up after some time. Hmm.
36. Responder one. Hi. চলো দাস।
This is IA condonation.
Yes, but
Last occasion also they are absent, today also absent.
Who are absent? POCSO?
Former advocate Mr. Boro I had,
POCSO?
not POCSO, but it is against equitable they have filed.
Union of India. Lord.
In
Oh, you are for the accused.
I am for the accused matter.
But then they are not there.
Yes, madam. Then again, they have not started the copy. Yesterday also I have talked to them. Kindly supply me the copy. They have not given. On knowing this fact, I have appeared myself.
Acha, otherwise the matter is down the list. So you do your other work and come back. By the time they will also come.
Yes.
Okay. You need not wait here. But then none appears for the DRI last time.
Yes. Today also not appears, madam.
Acha, you try to contact them now. Any junior advocate? We will take it up the serially in the matters. Okay. Otherwise, counsels are not here. 4 Monday. I saw Miss Ann Chaudhary here.
It's a criminal appeal jail, Lordship.
তাহলে বেল লম বলি ভাবি লুসি গো jail appeal
Yes, Lordship.
coming up for the first time.
First
Yes,
time.
Miss Chaudhary. Yeah, here. Yes, yes. So this has come up for the first time, Miss Chaudhary. You are amicus. Legal aid. So what is the offense? What is the conviction?
70 and 370. 10 years.
370 is what? Uh-huh.
Women trafficking.
Oh, of the BNS, right? IPC.
Yes.
370.
Human trafficking.
Yes.
Okay, I'll admit this matter today.
Yes.
Heard Miss N. Chaudhary, learned legal aid counsel appearing for the appellant, and Miss S.H. Bora, learned APP for the state for respondent number 1. This is a criminal appeal filed under section 415(2) of BNSS 2023, by which the appellant has challenged. This is a criminal appeal from jail, by which the appellant has challenged the judgment and order dated 31/10/2022, passed by the learned session judge, Sibsagar, in sessions case number 30, within bracket S-S, of 2014. Full stop. By the said judgment and order, the appellant was convicted under section 372, no, 370, slash 372, read with section 34 of the IPC. So there were more convict.
Not Lordship. Other accused, co-accused was died during trial, Lordship. So
Oh.
not only one who is convicted for 10 years. And almost more than 4 years, she has already served the sentence.
From the date of conviction?
Yes, at the time of
Trial.
from the trial.
Trial.
And they are convicted.
Okay, it's read with section 34 of the IPC, and was sentenced to undergo RI for 10 years with fine of rupees 10,000, and in default of payment of the fine, to undergo SI for another period of 6 months under section 372, read with section 34 of the IPC. And he was also further sentenced to undergo RI for a period of 10 years with fine of rupees 10,000, and in default of payment of fine, to undergo SI for another 6 months under section 370, read with section 34 of the IPC. Full stop. The sentences were directed to run concurrently. Para. Call for the trial court records. Oh, what did you issue notice?
Notice.
Petitioner to take, appellant to take steps for service of, otherwise notice is not required, right?
Otherwise not required, but it's a formal.
Okay, you take, if it is not served, we will take it up. The appellant is directed to take steps for furnishing steps for service of notice upon respondent number 2 by speed post with AD or by usual process. Call for the trial court records. List this matter.
After 4 weeks.
The Indian file.
Because 4 years is inside.
But convicted is not applicable because the person has
Ah.
7 people will not apply.
Okay, you file an application then?
Date may
Okay. After, when can you file the application? When should I take it up?
after 6 any date.
List this matter on 24th, 26th of August, 2026. Yes, Ms. Barpujari, Legal Aid Counsel. AC2 বন্ধ করে দিবা নি একটু সাইড হবে পার্টি বই বই রয়েছে এটা বলতে যাই jail appeal conviction is under POCSO. Let the notice go.
Yes.
Heard Miss Dipanjali Borpujari, learned legal aid counsel for the appellant, and Miss S.H. Vora, learned APP for the state. This is a criminal appeal filed from jail. Filed by the convict from jail, challenging the judgment and order dated 27/6/2025, passed by the learned additional session judge, cum special judge, POCSO within bracket, Morigaon, Assam, in POCSO case number 390 of 2023. Full stop. By the said judgment and order, the appellant was convicted under section 10 of the POCSO Act, as well as under section 354.
Yes, Doctor.
As there are other 448 also.
448
Acha,
also.
convicted under 354/448 of the IPC, read with section 10 of the POCSO Act. And was sentenced to undergo
5 years.
sentenced to undergo
5 years.
RI for 5 years with fine of rupees 5,000, and in default of the fine to undergo a further rigor RI for 3 years, 3 months
3 months.
under section 354 of the IPC. Full stop. The appellant was also sentenced to undergo fine only, undergo a sentence of fine to an amount of rupees 1,000, and in default to undergo further imprisonment for 1 month under section 448 of the IPC. Full stop. The appellant was also also sentenced to undergo RI for 5 years with fine of rupees 5,000, and in default of the fine to undergo further RI for 3 months under section 10 of the POCSO Act, right?
Yes, Doctor.
These were all to run concurrently.
Yes.
Where is that? Oh, yes. The sentences were directed to run concurrently. Oh, God. Yeah, issue notice. Since the offense of POCSO Act is involved in the present case, the appellant to take steps for service of notice upon respondent number 2 through the through the registry. Huh? Government, yes. Through the registry and enrouted through the office of the enrouted
Not as per practice direction.
as per practice direction, Didier. Through the registry as per practice directions. Call for the trial court records. List this matter after 2 weeks, after 4 weeks,
Not sure.
on a date to be fixed by the registry. Will you file any IA for this? D. Devi. Who is this D. Devi? I'm unable to locate.
Yes, Lordship, D Devi, I am also not.
Okay, let us take it up after some time.
After some time, no.
Mr. Chamua,
7 also, it's a jail appeal.
The seven, now in this case, I am appearing.
you are there.
Section 10 of POCSO.
What? Why Chamua was first there and you are now?
Some problem with the client, so he returned the file.
Acha. Otherwise, this is a jail appeal.
It's
Yes,
a jail appeal.
And you are a legal aid
Legal
counsel.
income.
Okay. Heard.
Conviction under section 10 for 10 years. Till now, 2 years, 2 months. He is
Mm.
behind the bar logic.
So total period is 10 years.
10 years.
Only POXO.
Only POCSO.
Also 6.
6. Okay. Heard Miss B. Sharma. Learned B mane pura likhiba. Bijita Sharma. Learned legal aid counsel representing the appellant and Miss S.H. Bora. Man, dingy to bhangi go, matter. This is a criminal appeal filed by the convict from jail, challenging the judgment and order dated 8/8/2024, passed by the learned Special Judge Poxo Kamrup, Amingam, in Special Poxo case number 58 of 2018. Full stop. By the said judgment and order, the appellant was convicted under Section 6 of the POXO Act and was sentenced to undergo a rigorous imprisonment for 10 years with a fine of rupees 20,000 and in default for payment of fine to undergo RI for another period of 3 months under said Section 6 of POXO Act. Issue notice. Since the offense pertains to the POXO Act, the appellant to take steps for service of notice through registry as per practice directions. Call for this trial court records. List this matter. You have an IA here. List this matter on 27th of August, 2026.
On the
In the IA, you write, Heard Miss So-and-so etu hobo. This is an application for suspension of sentence and for release on bail of the convict applicant. Full stop. The applicant has prayed for suspension of the sentence imposed upon him by judgment and order dated 8/8/2024, passed by the Special Judge POXO Kamrup Amingam in Sessions case number or Special POXO case number 58 of 2018. This application will be considered on receipt of the trial court records. Oh, here also you have to take notice.
In
Yes.
this case, M.K. Brown appeared during the delay condemnation. So
Mm.
I may approach her whether probably he will appear in the main case also because in the delay condemnation petition, she was appointed as legal aid counsel. So today,
Okay, but then without notice can we appoint her?
no, because once
no.
notice was issued in the delay condemnation. So, or I have to serve a copy to her or I have to take fresh step through registry.
Let the notice be issued to the respondent number 2. Thereafter, Lordship may consider.
If there is no reply, then we will.
Yes.
Okay, issue notice. The appellant to take steps for applicant to take steps for service of notice upon the respondent number 2 through by following the practice directions. List this matter after. I'll give you a date. I've already fixed a date, right? List this matter on 27th of.
4 weeks will be in the month of September will be better.
Uh,
Also call for.
okay, then change the date to 10th of September
Right.
in both the applications. 10th of September.
Lordship, Miss B. Sharma's name may be reflected in the
Yes,
cause list.
my
next
name-
time, Lordship.
Oh yes.
Instead of.
The registry is further directed to reflect the name of Miss B. Sharma for appearing for the appellant
Yes.
in the cause list instead of Dr. A. Chamua. Both. Hmm.
May it please your lordship,
Ah.
in this case, I am convicted under section 10 for, and I'm sentenced to.
10 of POCSO?
6 years, yeah, postcode.
Okay, let the notice go.
I'm-
Heard
And America has
Mr.
been already appointed.
Oh, she's already there.
Yes, Lordship.
This is not for the first time.
No, your
No,
lordship.
Lordship, already
the-
issued, notice has been issued to respondent number 2 and accordingly she is appearing.
Acha, I think appeal it is for the first
This
time.
year may be called for.
Please hear.
But there was no notice. Nothing had come. This is the first time. No order as
Notice was issued to respondent number 2 on the earlier occasion, Lordship.
Earlier occasion means
On
Delay.
24th 11, I.
delay condemnation.
No,
No.
Lordship.
But here there is no order.
Lordship, maybe
IA.
IA.
I also there is no order.
Lordship, kindly go through the office now, Lordship.
Office note, there is none. There are only two
But
pages
in my
here.
petition, it was on 24/11/2025. That notice was issued to
Huh?
respondent number 2.
These are all filing papers. There are no orders, no office note, nothing.
Lordship Registry has issued notice to respondent number 2.
This is only an acknowledgement of the filing. I don't know, how did she, and her name is also reflected.
Yes.
Okay, I don't know. Okay, as far as the IA is, IA, do you want to move it now? But there,
No, your lord.
There is
okay,
no TCR.
let the trial court come.
Yes.
Okay, heard Miss T. Dewey, Mr. T. Dewey, learned, you're the amicus?
No, no, your lord.
Oh, acha. Learned counsel for the appellant and Miss S.H. Bora for the respondent number 1 and Miss
T Parashar, your lordship.
T. Parashar, learned amicus curiae for respondent number 2. This is an appeal. This is a criminal appeal filed by the convict under section 450 within bracket 2 of BNSS 2023, challenging the judgment and order dated 8/5/2025, passed by the learned special judge POCSO, Sunitpur, in special POCSO case number 60 of 2022. Full stop. By the said judgment and order, the appellant was convicted under section 323 of the IPC and section 10.
Section
Yes,
10.
Jan of
Wait.
Clockwork.
320, only 323 IPC.
No, your lordship, section 310.
Oh, there are more.
Yes, your lordship. At page 71 of my
Acha,
email.
okay. No, 323 and POCSO. 323 and POCSO, I think.
Yes, your lord. Under 323, I've been sentenced for a period of
Huh.
1 year, your lordship.
Acha.
For POSCO, I'm sentenced for a period of 6 years.
Convicted under section 354 also, or 354A, capital A, within bracket, / 323 of the IPC, read with section 10 of the POCSO Act 2012, and was sentenced to undergo SI for a period of 1 year under section 323 IPC, and also to undergo RI for a period of 6 years with fine of rupees 10,000, and in default of the fine for SI for a period of 3 months for the offense under section 10 of the POCSO Act. Yes. The sentence under other sections are not provided in view of section 42 of the POCSO Act 2012.
Yeah.
Call for the trial court records. List this matter after 4 weeks on a date to be fixed by the registry. In the IA, you write, this is an application for suspension of sentence under section 430 of the BNSS 2023 and for allowing the applicant to go on bail. Full stop. The applicant has challenged the Oh, the applicant has prayed for suspension of the sentence imposed upon him by judgment and order dated 8/5/2025, passed by the learned special judge Pokso Sunitpur in special case number 60 of 2022. Full stop. The applicant was the applicant was convicted and sentenced under section 323, read with section 10 of the POCSO Act, and was sentenced to undergo SI for a period of 1 year under section 323 and RI for a period of 6 years with fine and default stipulation under section 10, what 10, no? Under section 10 of
10
the
of
POCSO
POCSO
Act 2012. The present application will be considered after receipt of the lower court record, trial court records. List this matter on
After 4 weeks?
after 4 weeks.
I'm very grateful.
This is your appeal.
Yes, Lordship.
So leave is done,
Lordship.
granted.
His leave is granted, Lordship,
Ach.
and delay under, Lordship.
Or delay was also there.
Yes.
Okay.
Poorly.
Heard Mr. S.H. Miss S.H. Bora, learned APP for the state. This is an appeal filed under section 378, within bracket 1, within bracket small b of the CRPC 1973. Bracket or TDR, section 419, 1B of BNS 2023, by this bracket close by the state of Assam. Full stop. The appellant herein has challenged the judgment and order dated 11/2/2025, passed by the learned court of additional session judge, cum special judge Pokso, Dhubri, in Pokso case number 90 of 2021, by which the respondent was acquitted of the charges under section 448/376 of IPC, read with section 4 of the POCSO Act.
Yes, Lordship.
Full stop. Para. It is noticed that leave was granted to the appellant for preferring the instant criminal appeal. Call for the trial court records. Appellant to take steps for service of notice upon the sole respondent. This one will be what? This one will be by speed post, or you will send it through the
Through
OC?
the OC, Lordship.
But there are other charges also, no?
Yes, because POCSO is also there.
POCSO
Lordship.
is also
Yes.
there. Okay. Through the by speed post as well as by so and so, huh?
Lordship, because since it's a POCSO case is involved, through registry and via PP office.
Okay, then do that only. To take steps for service of notice through the officer in charge of the concerned police station. I have case ki koi to trial court records call korilu. Call for the trial court records. List this matter after 4 weeks, huh?
Yes.
On a date to be fixed by the registry.
Yes.
May I please the lordship? On last occasion, my lord, I am appearing
You are
for
this side?
a respondent.
Acha.
Last occasion, my lord, the leave petition was allowed.
Read petition?
Leave petition.
Acha.
Leave petition was allowed, my lord.
This
And,
is a criminal appeal, it seems.
Yes, my lord.
Ah,
The NI Act case, 138.
138 and I
NI Act case.
This is against the conviction.
Lordship, against the acquittal.
Oh, against the acquittal.
Acquittal.
So you are the informant.
No, my lord. I am the accused.
You are the accused. What happened to the informant side? This one. Complainant side.
They are absent.
Mr. A. Sakya and Mr. B. Chaudhary.
They are absent today, my lord.
there was no last occasion. This has come up for the first time.
No, my lord, on last one, leave petition was there. That was
Acha,
disposed.
acha, leave petition.
Leave petition was disposed of and the registry was directed to register the appeal, my lord.
But today the appellant is not there.
Lordship, one direction may kindly be, one observation may kindly be made, my lord. We have not received the copy of the appeal, my lord.
Acha, we will take it up after some time. They might turn up.
Lordship.
Okay, or after some time. If you know these councils, you can
No,
also
my lord,
inform
don't
them.
have their numbers, my lord.
Okay. Mr. A. Saikia, Mr. A. Saikia. No, Mr. A. Saikia and B. Chaudhary. Who is B. Chaudhary? No idea.
No.
You were there when the leave application was allowed?
No, my lord, my junior
Okay.
colleague was appearing earlier.
Okay, let us wait. We will call up for the second time.
Lordship.
Oh. What is the conviction about? What has been sentenced? What has been convicted?
This is against acquittal.
Oh, this is against acquittal. NI Act. Okay, let the notice go. Okay. Where is the conviction? Which page it is? Compensation given or imprisonment also given?
Oh, your lordship, it's for acquittal, your lordship.
Oh, acha, acha, acquitted,
Acquittal.
yes. Where is the acquittal order?
Lordship judgment order dated 9/1/2025. Lordship will get,
Acha, I've got it,
what
yes.
is it?
Hmm.
Order to
68 page.
page number,
68.
page number 68, lordship.
Okay, heard her miss
K. Bhattacharya.
K. Bhattacharya, learned counsel for the petition for the appellant, and Miss S.H. Bora, learned APP for the state. By this application, this is a criminal appeal filed under section. Where is your appeal petition?
Under section 419, subsection 4 of BNS.
Yes. Filed under section 419, within bracket 4 of BNSS 2023, by which the appellant has challenged the judgment and order dated 9/1/2025, passed by the learned civil judge, within bracket junior division, number 3, Kam, JMFC Kamrup M, in CR, within bracket NI, case number 3519 of 2017. Full stop. By the said judgment and order, the appellant, only one respondent.
Yes, lordship.
Yes, your
The respondent was acquitted of the charges.
Under section 138 of NI Act.
Only 138, na? Yes, under section 138 of Negotiable Instrument Act 1881. Any leave required that was granted?
Leave
Yes,
was
lordship.
granted.
Leave was
It is noticed that the
29th May.
uh-huh,
Leave was already granted on 29th.
it is noticed that leave to file an appeal against the said judgment and order was granted by this court. By the order dated, you remember?
Yes, your lordship, 29th May 2026.
By the order dated 29
May.
May 2026. Call for the trial court records. Issue notice upon respondent number 2 by speed post with AD or by usual process. List this matter after 3 weeks on a date to be fixed by the registry. Acha, sir, what was the case number about this? It is. Call for the trial court records, call for the trial court records in connection with pertaining to whatever Heridia. CR NI case number disuni ke aba no 35, it's okay, as mentioned above. This is also a state appeal.
Appeal, lordship.
Okay,
Leave was
heard Miss SH Bora, learned APP for the state. This is a criminal appeal. filed under section 419 within bracket 4 of BNSS 2023, by which the state, oh, no,
Against the order.
491 of the BNSS filed by the state of Assam, challenging the judgment and order dated 17/2/2025, passed by the learned Special Judge POCSO, Golaghat, in special POCSO case number 83 of 2024, by which the respondent was acquitted of the charges. Acquitted of the charges under section 87.
Yes,
87/64
2.
within bracket 2 within bracket small m of BNS 2023, read with section 6 of the POCSO Act.
Lordship.
Full stop. It is noticed that the leave to file the present appeal was granted by this court. You know the date?
Yes, Lordship, 1/6/2026.
Okay. By the order dated 1/6/2026. Full stop. Call for the trial court records. Issue notice to the respondent. Full stop. The appellant to take steps for service of notice upon respondent through the officer in charge of the concerned police station. List this matter after 3 weeks on a date to be fixed by the registry. I is for what?
I is for condonation of delay, Lordship.
And it was not condoned.
It was not condoned.
No. You should have said it before,
Lordship.
because unless it is condoned, we will not take it up.
Yes, yes,
You should have told me before.
yes.
এটা তুমি চেঞ্জ করা এরি কি কয় আই দিয়া 562 this is an application under section 5 of the Indian Limitation Act 1963 for condoning the delay of 264 days in filing the. Actually, this delay application should have been taken before leave.
Yes, Lordship, yes.
In filing the connected criminal appeal. Issue notice, returnable by 3 weeks. Petitioner to take, applicant to take steps for service of notice upon the sole respondent through the office of the, through the officer in charge of the concerned police station, since this is a matter where the respondent was acquitted of the charges under the POCSO Act. List this matter after 2 weeks, or I'll give you a date. You have to serve the notice.
Yes, Lordship.
List this matter after 2 weeks on a date to be fixed by the registry. Appeal or to order na lage. Okay.
And Lordship-
Appeal was registered? No, na?
No, Lordship.
Perhaps registered. 203.
No, appeal was registered, yes, sorry, Lordship. Without going through the delay petition. Condonation.
Without condoning the delay, it is registered. Okay. Let them notice. To register hobo jodi etu dismiss hoy jay ki okane register kori. Pehle condone tar se leave tar se hobo lagse. Hobo de etu notice di de. You want the records in the condonation application? No, not required.
Lordship,
Let him come first.
yes.
Call for the case in
PCM
record na lage.
for not.
Na lage. Only notice should go.
Lordship.
Yes, 13. Miss Ann Borwa. After
It's a
some time.
criminal
Yeah.
appeal, Lordship.
Huh?
State is not a party here, I suppose.
It's a party.
State is a not party.
PP Assam I can see in the
Item 13, Lordship.
13.
Yes. Our names are not shown in the.
Appellant. Oh, yes, Radha Ram. No, you are there as respond number 2.
Lordship.
Later on, you were impleaded.
Lordship. But cause.
Okay, let the council come after some time.
Yes, Lordship.
2-9, huh? No, this bench was supposed to sit after rising, no? So some people might not have got the notice.
Maybe.
They will think maybe in the second half it will reach after some time. 15. Yes, appeal.
My please, your lordship.
Hmm.
Herein, your lordship, the appellant herein, he was the complainant before the.
Acquittal.
Acquitted, your lordship.
You are against acquittal.
Yes.
Your leave was granted earlier.
Leave was granted and thereafter this.
Okay, heard Mr.
Yam Khan.
A.M. Khan. A.M. Khan, learned counsel for the appellant, and Miss S.H. Bora. Is she a party? No.
No.
Normally, state is there as a performer respondent.
And I.
And I,
State is a formal party.
But there is no, they are not there. It's okay. Heard Mr. A.M. Khan, learned counsel. By this, this is an application filed under section 419, within bracket 4 of BNSS 2023, by which the appellant has challenged the judgment and order dated 27/11/2024, passed in NI case number 47 of 2023 by the learned Chief Judicial Magistrate Goalpara, Assam. Full stop. By the said judgment and order, the respondent was acquitted from the charges under section 138 of NI Act. Full stop. It is noticed that leave to file an appeal was granted by this court by the order dated by this court.
order is not there, your lordship, but the miss.
By this court. Full stop. Issue notice. Appellant to take steps for service of notice upon respondent by speed post or by speed post with AD or by usual process. Call for the trial court records in connection with the aforesaid case. List this matter after 2 weeks or 4 weeks. 3 weeks on a date to be fixed by the registry.
Please,
Oh.
if this is the appeal against the order of acquittal.
Against acquittal?
in
NI?
NI.
Okay, heard Mr. A. Sharma, learned counsel for the appellant. And, is she a party? No. Huh? State is a party? No, you are not there. Okay. This is a criminal appeal filed under section 4194 of BNSS 2023, 4 within bracket, by which the appellant has challenged the judgment and order of acquittal dated 18/2/2026, passed by the learned Judicial Magistrate First Class Kamrup M. in complaint case within bracket NI number 2465 of 2020. Full stop. By the said judgment and order, the respondents, the respondents were acquitted of the charges under section 138 of the Negotiable Instrument Act 1881. It is noticed that leave to file an appeal was granted by this court by the order dated
17/6/2026.
17/6/2026. Issue notice. Petitioner to take steps or appellant to take steps for service of notice upon the respondents by speed post by AD, with AD or by usual process. Trial court record call for the trial court records in connection with the aforementioned case. List this matter after 3 weeks on a date to be fixed by the registry. 17 after some time. Mati diba khaliso.
Please, Your Lordship.
Mm.
The appeal against conviction. It has come up for the first time after delay condonation, Lordship. Under section 8 and 12. Only as one aspect, Lordship, sentence is of 4 years. I have served more than 2 years. So perhaps the appeal may be admitted, but there is also an IA for suspension.
2 years he has already been inside.
Yes.
We cannot also take into, were you on previous bail? No.
So
Okay.
Amicus appointed in the earlier occasion, Lordship. And let
Or
the
POXO is there, right?
POXO is there, Lord.
Let the notice go at least.
To be
Okay,
amicus.
heard Mr. A. Atria.
I think already appointed.
Yes,
Lordship.
Lordship. Amicus has been appointed. in that-
Appointed in delay condonation perhaps. Not here,
Yes, Lordship.
not in the main appeal.
next step.
You take this notice thereafter.
Yes.
A. Atria, learned counsel for the appellant and Miss S.H. Bora. This is a criminal appeal filed under section 415, wherein bracket 2 of BNSS 2023, by which the appellant has challenged the judgment and order dated 16/9/2025, passed by learned special judge Bojali Patsala in special POXO case number 11 of 2020. In I've already said violence, insolence, full stop. By the said judgment and order, the petitioner, only one in number, the appellant, one.
One in number.
The appellant was convicted. Ruba.
Under section 448 of IPC, Lordship.
Page 20 of the.
Page 20. Oh, yes, huh? They were, these are all sentences. 20 is the, no, 20 is the beginning of the judgment.
Yes, Lordship, that.
Trying to take out the conviction part.
Under section 448 of IPC, read with section 8 and 12 of POXO Act. Page 20, accused details, Lordship.
Sentence is page 39.
A sentence I've got, but
Page
conviction.
39.
448 and 8 and 12.
8 and 12.
Okay, is convicted under
Yes.
section 448 of IPC, read with section 8 and 12 of the POXO Act. And the appellant was sentenced to undergo RI for 4 years with a fine of rupees 5,000, and in default for the payment of fine to undergo further SI for 1 year of under section 8 of the POXO Act. Full stop. The appellant was also sentenced to undergo RI for 2 years with fine of rupees 3,000, and in default SI for another period of 6 months under section 12 of the POXO Act. Full stop. The petitioner was also sentenced for payment of a fine of rupees 1,000, and in default thereof to undergo SI for 3 months under section 448 of the IPC. The sentences were directed to run concurrently. Yes,
concurrent.
the sentences are directed to run concurrently. It is noticed, oh, Nalai, the issue notice, the petitioner to take, the appellant to take steps for service of notice upon respondent number 2 by following the practice directions, that is through the registry and that is, yes, through the registry and also through the office of the PP. Call for the trial court records. List this matter after 3 weeks. In the IAU, right? This is an application for suspension of sentence and for allowing the applicant to go on bail in connection with the judgment and order dated 16/9/2025, passed by the learned special judge Bojali Patsala in special POXO case number 11 of 2022, by which the applicant was convicted and sentenced under Section 448 IPC, read with Section 8 and 12 of the POCSO Act. The present application will be, issue notice upon the respondent, applicant to take steps for service of notice upon respondent number 2 by following the practice directions, that is through the office of the registry, and also through the office of the PP. Not also, through the registry as per the practice directions. List this matter after 3 weeks. Yeah, better to give a date perhaps. List this matter on 2nd of September. Both the matters, sir.
Public Lordship, deeply appreciated.
Yes, Mr. Hajarika.
Yes, Lordship, may kindly peruse the order impugned page 11.
I is for suspension.
Yes, Your Lordship.
So what is the conviction about?
Yes, page 13, Your Lordship. For
Convicted
307,
under 326 34 307. Attempted murder.
307 for 10 years and also for 326, 5 years, Your Lordship.
Heard Mr. R. Hajarika?
RP.
R.P. Hajarika, but then here it's written R.
Ah.
Mr. R.P. Hajarika, you write doctor or no?
No.
Acha. Heard Mr. R.P. Hajarika, learned counsel for the appellant, and Ms. S.H. Bora. This is an appeal filed under Section 415 of the BNSS 2023, by which the appellant has challenged the judgment and order dated 19/12/2025, passed by the Learned District and Session Judge Sunitpur in Sessions Case number 120 of 2018. Full stop. By the said judgment and order, the appellant was convicted under Section 326/307, read with Section 34 of the IPC. Acha, appellants, right? Or
Appellant.
one?
Yes, 8 appellants were there.
But here
Uh,
only
yeah,
one,
some other
Your Lordship.
appeal memos are also there. Those are
Here one appellant.
Only one.
Only one. Only one.
Otherwise, 9 were convicted.
No, 8 were
Eight.
convicted.
Mm.
Here's the accused number 8. This present petition accused number 8.
Accused number 8.
Eight.
There are appeals by other convicted persons.
2 appeals were there.
Are they have been taken up by this court?
Yes, not by this court, Your Lordship. But,
I mean, we
but,
can,
other than accused number 1 and
because
8,
there will be one lower court records. So
yes,
better if
yes.
all the matters are tagged
Tagged
together.
together, then it will be.
Do you
continued
have
for
the numbers of the other appeals?
Yes.
Okay. Right. Ki kolo hetu no? 34 of the IPC. And was sentenced to undergo the appellant along with others, along with 7 others. Were sentenced, no? Along with 7 others. And was sentenced to undergo RI for 5 years with a fine of rupees 10,000. No, RI for 5 years with fine and default stipulation under Section 326, read with Section 34 of the IPC, and was also sentenced to undergo RI for 6 months with fine 6 months. No.
Your Lordship, in
Doctor.
default, RI for.
5 years and all that under 326, right?
Yes.
And in default of the fine hearing. Oh, and also to undergo RI for 10 years with fine and default stipulation under Section 307, read with Section 34 of the IPC.
Yes.
It is noticed that by the said judgment and order, there were altogether 8 accused persons who were convicted and were sentenced. And the appellant is one of them. It is also stated at the bar that few other convicted accused persons or few other convicts had filed appeal against the said conviction and sentence before this court. And since there will be one trial court records,
Yes.
the said matters may be tagged up and taken up together by this court. The numbers of other criminal appeals are
Criminal appeal number 16 of 2026 and criminal appeal number 47 of 2026.
16 of 26, 47 of 26. Huh? As such,
And-
it is directed.
And another was 123.
It's okay, let these two come.
Oh, these two. Along with
As such, the present appeal be listed along with the appeal numbers given aforesaid. Whether the trial court records have been called in that matter,
call for.
called. It is also seen that trial court records were called with regard to the aforesaid appeals in connection with the aforesaid appeals. As such, list this matter along with the same. Notice there also same respondents,
Same. Same.
same respondents,
Complaining is there. Bobby the same. Same.
same. So it is also stated at the bar that notices were issued to the same respondents in connection with the other criminal appeals. As such list, do you know the date where
Yes,
those?
only in respect of the bail of the accused number 1, it is fixed on Friday, on 14th of this
Criminal appeal.
criminal appeal.
Which one?
Accused number 1, Akash Munda,
That is number is 16
and
or
criminal appeal
47?
number 47.
47.
List
47,
this matter
then I
this
number
Friday. This Friday.
This Friday. Along with the IA, his I number is also
Okay. It is also seen.
522. 522.
It is also seen that criminal appeal 47 of 26 is listed on Friday.
Right.
As such, list this matter along with the same.
Oblige of.
Yes, no.
Yes, no.
Dear, that this is an application for suspension of sentence and for allowing the applicant to go on bail in connection with the judgment and order dated in connection with the punishment imposed on the applicant by judgment and order dated 19/12/2025 passed by the District Session Judge Sonitpur in Sessions case number 120 of 2018 under section 326, 307, read with section 34 of IPC.
Obliged.
Here to notice is not required.
Not required.
This
also-
application will be considered after receipt of the trial court records. List this matter along with the other matters. Yes.
Oblige, Doctor.
Your Lordship, it has been filed, Lordship.
20.
Yes, Lordship.
I don't know why these advocates are not there. Okay, none appears, I will say.
In the earlier occasion, they have not appeared.
Perhaps they know they are not interested.
Lordship.
Is it feasible if I keep it alive or we can close it?
Lordship, Can give a last chance. Let's let the matter be listed.
None appears on call for the petitioner. However, Ms. S.H. Bora, learned APP, submits the charge sheet in connection with the present case has been submitted. White charge sheet number?
White Circuit number 16/2025, dated 12/02/2025.
Allah. List, but for the ends of justice, list this matter again after a week. No, list this matter on 17th of August.
Lordship.
If on the said day the petitioner does, the learned counsel, no, if on the said day the petitioner goes unrepresented Adverse orders will follow. 23. Yes, Mr. Ahmed.
Here, Your Lordship, after registration of the case, one of their brother was arrested and subsequently they filed this application before this honorable court during investigation. They were granted interim relief. They appeared before the investigating officer. Investigating officer also submitted charge sheet. Now, during pendency of this case, okay, the informant appeared and they submitted that I have violated terms and we have violated terms and conditions, and accordingly they have filed one complaint before the concerned court also. So thereafter, also, due to that submission, also, this honorable court wanted to see that whether anything there in the charge sheet, whether anything is mentioned regarding that non-cooperation or not. For that, Lordship, trial court record was called for. Now, trial court record is here, and I have also obtained the certified copy of the charge sheet, Lordship, and nowhere it is said that I have violated the terms and condition of the interim order. And in fact, the complaint which they have filed, that is treated to be petition under section 125 BNS, that earlier 145 proceeding, dispute between parties. And thereafter, Lordship, that petitioners also appeared in that proceeding and also submitted that regarding that disputed land, they have already filed one title suit. So all these developments are there, and already the case is now pending at the stage of evidence.
So as of now, here, you are on interim.
I'm on interim and the case is proceeding and that is in evidence stage. Lordship.
And conditions, they say that you have not followed the conditions of the interim bail
During
order.
investigation.
During investigation, now charge sheet has come.
Now charge sheet come, Lordship, that they appeared before the trial court and
Okay.
charges are framed and the matter is fixed for evidence. So my submission to the Lordship is that they have not violated the terms and conditions, and the trial is progressing. So at this stage, the interim order may be made absolute. And already regarding disputed land, they have already filed the title suit. Where the period when they said that I was violating the terms and conditions.
Yes. You were never an absconder before.
Never absconder.
I'll just see the last order. Wait.
Sure.
But last order, the TCR, wrong TCR came and right TCR was directed to be.
Now it has come.
Now it has come.
In fact, in the last order, my lord, that PS case has been wrongly mentioned as 510. The TCR has come of 501 PS case. And I have checked, my lord, that is the same FIR.
The correct one has come.
Correct one is come.
And I
Okay,
have
now in the said facts, what happened? Charge sheet, you got interim when the charge sheet was not submitted.
submitted during investigation.
Acha.
And
So
I
he
have
was an interim.
Lord, I have also filed one additional affidavit, Lordship, to bring on record the title suit, Lordship, they have filed. The
Acha, in that interim order, only condition was that you have to cooperate
Go for it.
and will not hamper temper with the evidence.
Sure.
But what was the allegation? You had hampered temper with the evidence.
So they have filed one objection, Lordship will file.
My lord, here, friend want to submit something.
Yes, ma'am. We are no longer engaged in this case.
So you are no longer there in the case. You have withdrawn. Okay, doesn't matter. But then let's see what.
Their objection is there, Lordship, objection from that record, running page 55, Lordship, na kindly see that is the complaint. And they
Now
have
that
said
the charge sheet is submitted, case is on, you have filed your title suit
title-
and 145 proceeding is also going on, right?
Yeah.
Hey, let him be on bail. It is there.
My lord, I have gone through the search sheet copy in the scan copy. There is no such mention of regarding violation and all these things.
Okay. Heard Mr. A. Ahmed, Learned Counsel, appearing on behalf of the, there are many applicants.
Two applicants.
Appearing on behalf of the petitioners. Also heard Ms. R.R. Kaushik, Learned Additional Public Prosecutor for the state. By this application, the petitioner has prayed for pre-arrest bail in connection with Sri Bhumi PS case number 501 of 2025, registered under section 331, within bracket 4, 305, small a, 324, small a within bracket, 324, 5, as well as section 35 of BNS 2023. Where is the FIR here?
FIR at page 10.
The FIR in connection with which, the petitioners are apprehending arrest was lodged on 23/11/2025 by the, no, date is different. Date is
3/12/2025, page 12.
3/12/2025, by which the informant had alleged 3/12/25. This is also officer in charge?
The signature on that day, it was registered.
No, registered on 23/11/25.
Yes.
23/11, bro.
So 0312, page 18 is the original copy road. That register. Initially, one inquiry was made. On that day, Lordship, it was not registered. Subsequently registered on 3/12/26.
Received and entered. So registered on, registered I don't want. It was lodged on which day? 23/11.
Lordship.
23/11/25, by which the informants alleged that at 1 a.m. on the previous night, the accused persons, 3 in numbers, arrayed in the said FIR, which included the present petitioners, stole furnitures from the shop of the informant by breaking the lock. Full stop. The informant further alleged that the petitioners and another had completely destroyed his shop, and a financial loss of rupees 3 to 4 lakhs had resulted with regard to the informant. It is noticed that the petitioners were enlarged on pre-arrest bail by order dated 12/12/2025 on the conditions mentioned therein. The learned counsel for the petitioners submits that pursuant to the said bail order, the petitioners had appeared before the investigating officer and got their statements recorded. But he submits that the informant side had filed an application before the concerned court alleging that the petitioners had violated the conditions of bail.
So they have filed before police.
Or they had filed before the police, concerned court, before the police. He further submits that there was actually no violation of conditions of the bail, and rather, title suits were filed by the petitioners against the informant side, and that applications under section 145 of CRPC is also filed by the parties concerned, and the dispute is yet to be adjudicated upon by the respective courts. He further submits that the charge sheet has been submitted and there are no allegations in the charge sheet that petitioners have violated the conditions of bail. Mr. R.R. Kaushik, learned APP, also submits that in the copy of the charge sheet, there is no such averment that conditions were violated. And their statements are also recorded?
Well, that portion I have no knowledge because the scan copy has come.
That will not include case diary.
That I'll have to check.
I'll just see once. Case diary. I can also see case diary to just.
The charge sheet, it is there.
Charge sheet is mentioned, Manada.
That they appeared and they were arrested. Subsequently, because of the order of the Honorable Court, they were released. That observation is there in the charge sheet itself.
They were arrested earlier.
Because interim order is there, so they have to arrest and give bail.
That is okay. Statements and all are recorded. You appeared.
So that is the discretion of the IO, so I cannot say.
Acha, you appeared
Yeah,
within
I
10
appeared.
days. It is also seen, he also, Mr. Kaushik also submits that statements of the petitioners were recorded by the investigating officers and the charge sheet was submitted. Upon consideration of the submissions made by the learned counsels, more so in view of the fact that the petitioners are appearing before the court, more so the petitioners have appeared before the police, as well as they are appearing before the courts,
Right.
court of law. This court finds it fit that order dated 12/12/2025, by which interim protection was given, be made absolute. Full stop. The petitioners be permitted to remain on pre-arrest bail on following the conditions which were already mentioned in the said interim order. Petition is disposed of. Oh, I forgot. And they will also have to keep appearing before the trial court. It will with the further condition that the petitioners will appear before the trial court. Matter is in trial now. Before the commitment done. Commitment done.
Already committed, no, see, this is a magistrate tribal case.
Acha, acha. Okay, before the learned court, without fail. On each and every dates. Yes. Okay. Yes. You are on interim,
My lord. My lord, CD not received here.
not received. Okay.
received.
let me-
Postmortem report was also called.
Acha. Okay, bring that, both the reports. Okay, heard Mr. S.K. Jain, learned counsel for the petitioner, and Mr. R.R. Kaushik. Mr. Kaushik submits that the case diary has not been received and has prayed for and for another date for placing the same. Prayer is allowed. List this matter on
25th of August.
25th of August 2026. The interim order passed earlier shall continue until the next date of listing.
Same, my lord, CD not received.
25, okay.
Interim reason only.
Interim is there.
Right.
Counsel is not there. None appears on call for the petitioner. Mr. R.R. Kaushik, however, submits that the case diary is not available and has prayed for a date for placing the same. Prayer is allowed.
Same day, ma'am.
Huh?
Same day.
List this matter on 25th. 25th of August 2026. Interim order passed earlier shall continue until the next returnable date. 29. Council is not there. Last time also he was not there. That was on 11/6, Mr. Kaushik.
Yes, madam.
What happened? He is on interim.
My lord, as per my note, no mention of interim order, my lord.
There was no interim order.
My lord, CD also not received.
Call for the case diary.
My lord,
Okay, likha. None appears for the petitioner on call. However, Mr. R.R. Kaushik, learned APP, submits that the case diary has not been received. List this matter on 18th of August 2026. On which date the learned APP would produce the case diary. But it is on time listen. 32 time listen to. 30? 32. Oh, yes, 31. There was an adjournment. Yes.
32.
Mm.
Wait, please, also.
My lord will kindly see the.
Case diary is there.
Yes, TCR is there, my lord.
Or TCR. Okay.
This matter, my lord, it started as of a very serious case, my lord.
Acha.
Of,
Now it is no
Now,
longer
my-
serious.
Once the, my lord, appeal was filed, during the pendency of the appeal, that is bail, the police filed charge sheet, half of the accused persons are gone, my lord.
And my lord, the allegations have now come down to magistrate tribunal only. But in the meantime, what had happened, my lord, I have flagged marked it, my lord. On the very first day, my lord, when the charge sheet was laid down before the magistrate, straight away NBW has been issued, man.
That can be done, 82, section 82 of CRPC, but then they'll have to give reasons.
According, my lord, will kind of.
Reasons they have to give.
Yes, I have flagged marked it at page number 43. Initially, there were 22 accused persons, my lord. Now, my lord, there are only 10 accused persons, and all these offences are magistrate tribal.
Okay.
So, my lord, they will face trial, my lord.
But okay, they will face trial, but and NBWA challenge in a different proceedings. But as far as AB,
AB.
and they were the petitioner, there is only 1 year. Oh, there are 18.
18.
Oh,
But
18.
half of them are gone now.
So few of them are not there.
We are only for 9.
You are only for
Yes,
9
one was
petitioners.
arrested, accused number 1, remaining 2 to 10 we are
Mofial Haq is arrested,
arrested.
and 2 to 10 is before
Yes, yes,
this court,
yes.
along with others whose
They-
names are gone.
Yes, discharged.
They were discharged.
Yes.
So, what happened? You had appeared before the no, right?
No, because pendency of the way of the charge sheet was submitted.
Cognizance has taken.
Yes.
Yes, cognizance taken.
NBWA issued.
Yes. Gun bail, man.
But NBWs are issued now. Now the stage is little different.
No, first order. This is the first one.
Or you go and file your bail application before the trial court, before this magistrate.
Since, my lord,
Charge sheet is submitted.
it seems, my lord, this was done during the pendency of this bail, man. Otherwise, we could have done that. But since, my lord, this was done, perhaps, my lord, we can, my lord, pay for that also, my lord, because had it been a case where we have appeared or we have preferred the bail once the charge sheet was laid down.
So charge sheet you were shown as absconders.
Yes, yes.
Problem is that whether you will appear.
Yes, my lord. My lord, we have also filed a counter FIR, my lord. That is also there on the same incident, my lord.
So land grabbing, criminal trespass, all
Yes,
those.
Yes.
A fight between two groups.
Yes. FIR and counter FIR.
Okay. What do you say, Mr. Sharma? Okay, there was a fight between.
Tribal also, and cognizance has been taken, and apparently also on the first day NBW was issued. They will appear.
That is, of course, for the court to
Yes,
do, but
yes.
okay. I heard Mr. Surajit Das, learned counsel for the petitioners, and Mr. B. Sharma, learned APP for the state. By this application, the petitioners who were 18 in numbers had prayed for bail, had prayed for pre-arrest bail in connection with Sukchar, SUKCHAR, Sukchar Police Station case number 28 of 2026, registered under section 126(2), 118(2), 329(3), 117(2), 3032, read with section 3(5) of BNS 2023. The learned counsel for the, and it is stated at the bar that this application, no, like it is the learned counsel for this petitioner submits that this application was filed during the during the investigation stage, and when the instant application was kept, and during the pendency of this application, the charge sheet was submitted by the police after conclusion of the investigation. And in the said charge sheet, many accused persons were discharged. And amongst them, there are few petitioners. The FIR was against these 18 only, or there were more?
22.
Acha, petitioners also. Full stop. He further submits that the instant bail application may be considered only in respect of 9 petitioners. What? 8.
9.
9 petitioners who are petitioner number, you have called out.
Yes. My lord, two,
Hmm?
1 to my lord, 7
1 to 7.
and 18.
Huh?
1 to 7. 1, 2, 3, 4, 5, 6,
Ah.
7.
Okay, there are 7. Then
Yes.
another
Then
2,
petition number 18.
18. There will be one more. And they are petitioner's number.
Well, I verify and give it to them.
Okay, we can also do it. There is, you had shown me an order of cognizance. Where is that?
Yes, yes, page 43.
Page 40?
43.
43, okay, yes. So, Mofial Hawk. Mofial Hawk is not there. Okay. Amirul Islam, Sahidul, then Sayad, then Rahim Badsha, then Rahim Badsha, then Abdul Razak. Where is Abdul Razak?
Well, that's what I'm searching.
Maybe that's a different name. Abdul Razak. Abdul Azad SK. Ahad Ali SK. There's only one SK.
Yes.
But then you have to be sure.
I'll verify, madam.
Okay. And they are petitioner's number so and so. The learned counsel further submits that subsequent to the filing of the charge sheet, all the accused persons who were 10 in numbers were he submits that a total of 10 accused persons. The charge sheet was submitted against 10 accused persons, and out of them, accused person number 1 was arrested. He also submits that cognizance of offense was taken by the Court of Judicial Magistrate First Class, HSM, by order dated 8/7/2026. He submits that the FIR in connection with which the petitioners are apprehending arrest was lodged on, what is the FIR 18?
Yes.
Was lodged on 1/6/2026 by the informant stating inter alia that the petitioners by using sharp weapons surrounded the informant and his companions, and by verbally abusing the father of the informant, assaulted the informant's father, as a result of which father was hospitalized or what?
Yes.
As a result of which the father of the informant was referred to the hospital. Was taken to the hospital and was referred to a better hospital for better treatment. It is also stated in the FIR that the petitioners, along with others, had destroyed their house and had stolen articles. The learned counsel for the petitioners also submits that there was a counter FIR filed by the petitioners against the informant side. Full stop. He submits that out of the 22 accused persons, only 10 accused persons were arrayed as accused persons in the charge sheet. He submits that two parties over a disputed plot of land fought against each other and injuries were sustained by both the parties, by members of both the parties. Full stop. Mr. B. Sharma, learned APP for the state, however, submits that it is in the evidence. Oh, no, it further submits that both in the FIR as well as in the charge sheet, it is alleged that the petitioners had assaulted the informant side. And due to the said assault, the father of the petitioner, a father of the informant, received grievous injuries. Full stop. Para. Upon consideration of the submissions made by the learned counsels, and more so, seeing the fact that two parties had fought with each other over a disputed plot of land, this court finds it fit to enlarge the petitioners, that is petitioner number he will give, so and so, on pre-arrest bail, on furnishing of a bail bond of rupees 20,000 with one local surety each, under the following conditions. Petition is disposed of.
I'll give the list of.
Yes, you have to give.
Highly obliged, madam.
Leave petition. Yes, and condonation also.
May I please, Lordship? Lordship, please kindly grant the passover for time being. The learned counsel is on his legs on another protest.
After some time.
Okay.
This petition is disposed of, bail to dispose. $34. No one is there. Okay, after some time. Yes, Mr. Biswas. 36 or 5, you said? 36 to dear. Yes, you are for the Union of India or what?
Yes, Lordship.
Huh.
Lordship, in this matter, I am seeking some accommodation, Lordship, because today only I have received the files, Lordship. I've been newly engaged in this matter, Lordship. This matter was previously looked up by some other counsel, standing counsel, who had subsequently.
You are the CGC? What?
No, Lordship. I'm for the DRI, Lordship.
DRI?
Yes, I'm standing counsel. Lordship.
Okay, so it is your appeal and there is leave and delay.
Lordship.
So
I'm
he
just
is there,
seeking
you
some
can.
Accommodation for 1 week, Lordship.
Okay. Okay. Learned, Mr.
K. Brook, Lordship.
K.
K. Brook.
Brook.
Yes.
Heard Mr. K. Brook, learned counsel appearing for the DRI, and Mr. S.C. Biswas, learned counsel for the respondent. Respondents.
Respondents, yes. 1 and 2.
1 and 2, respondents. Mr. Brook submits that the case has been recently handed over to him, and as such he has prayed that, as such he submits that he wants to go through the matter and prays for some time. Prayer is allowed. List this matter on 17th of August, next Monday.
No, matter. I pray some more. They have not served us the copies of this.
Okay, you
In the
give the
meantime,
copies.
I'll serve,
Okay,
Today itself, some. Then let it come the last week of August.
okay. List this matter on 25th of August. Okay, you give him the copy. I need not write in
Today
the
itself,
order.
All the 3 methods.
Or I'll write it. I'll write it down. Okay. Learned counsel for the DRI is directed to serve a copy of the leave of the delay condonation application.
Condonation, leave petition as well as the matter.
No, only if his delay is condoned, we will go to leave.
Registered.
Not registered, but it will be registered.
Yes.
No, you give only delay application.
Yes.
The condonation application upon the counsel appearing for the respondent.
Probably delay and both the leave petition may be.
No, delay needs to be condoned first, then leave. Then whether there is merit in the case, then appeal. Okay?
Leave.
Yes, 35. You're there? This is again a leave and a condonation, yes?
Yes, Lordship.
Huh? Mr. Biswas, he also appears in this matter. What happened?
As a legal aid counsel in this matter.
Uh-huh.
He is appearing as a legal aid counsel in.
Acha, call Mr. Biswas.
Lordship.
S. Vishwas.
In the order, it's written SC Biswas.
Lordship, it has been wrongly.
Oh, acha. Okay. No, Mr. It's wrongly, your name is wrongly reflected in the last order of this case, saying that senior counsel Mr. S.C. Biswas should be served with a copy. You're not there, right, in 1335?
Actually, in the causeless, it was wrongly written S.C. Vishwas instead of S. Vishwas.
No, causeless is right.
As it was actually, I am not here.
They corrected it, but on the last three occasions.
Oh, okay.
given
That
the
is how.
S.
It's okay.
Problem.
So, what has to be done today? It's okay, Mr. Biswas. You are for the, you first move the delay application or delay is condoned.
Delay is condoned.
Delay is condoned. Leave is there.
POCSO is there, Lordship.
POCSO is there.
Yes.
So while condoning the delay, any legal aid counsel amicus was there. Representation on behalf of the this one of the
Steps
victim.
has been taken, but
No, delay is not condoned. Huh? Delay is not condoned. Your delay application is what? 4 to 8. 4 to 8. So 4 to 8 is before me. Delay is not condoned. Your service is not complete. Legal aid, senior counsel. Oh, this SC Biswas is wrongly given. And then notice has been issued upon respondent number 2 through officer in charge. Copy of the notice along with so handed over to APP. You have to bring the information again. Right.
I'll get the report.
Get the instruction.
Lordship.
Your name, please. Heard, miss?
D. Devi.
D. Devi. D. Devi. Your other matters were also there, which got postponed. What about item number 6, 7? 6? It's you. There is some other D. Devi. Okay, heard Miss D. Devi, learned counsel for the applicant. And Mr. B. Sharma, learned APP for the state. Notices were issued to respondent number 2 through the office of the PP. And as such, Mr. B. Sharma is directed to get the instruction as to whether the service upon the respondent number 2 is complete or not. List this matter for further consideration on. When can you bring it? To have a telephonic conversation?
Yes.
List this matter on 17th of August, next Monday.
for item number 6,
Hmm.
my name is reflected, but it is also a legal aid legal aid.
You are not the one.
I'm not the legal aid tutor. From my account, I have to, I have filed the appeal, but Mr. S. Biswas is appearing.
Where? Which one?
In item number 6, Digonto Rabha.
So you said you are not this D. Devi.
Okay, just now I have seen.
It is you.
Only.
Okay, then 6 to Mati Jason. Okay, so today, criminal appeal jail. You are the legal aid counsel.
Only.
Acha, legal aid counsel is S. Biswas, Sumit Biswas.
Yes, Sumit Biswas.
And you are his junior.
Yes, no.
And so, okay, you can appear. Although he is the amicus legal aid counsel, he is not there today.
No, no.
Acha. 6 at likha. Heard Miss D. Devi, learned counsel appearing on behalf of Mr. S. Biswas, learned legal aid counsel, representing the appellant in the instant case. This is an appeal filed under section this is an appeal, filed under section 415 of the BNSS 2023, by which the, from jail, appeal from jail, by which the convicted appellant had challenged the judgment and order dated 26/5/2025, passed by the Learned Court of Additional Session Judge Udalguri in sessions case number 32 of 2022, full stop. By the said judgment and order, the appellant was convicted under section 304 part 2 of IPC Only 304, right? IPC. And appellant was sentenced to undergo RI for a period of 10 years with fine and default stipulation. Call for the trial court records. In connection with the aforesaid case. List this matter. On after 4 weeks, you give a date on 16th of September 2026. There is an IA.
First day.
IA likha. This is an application for suspension of sentence imposed upon the applicant and for allowing him to go on bail. Full stop. The judgment and order by which punishment was inflicted upon the appellant was passed on 26/5/2025 by the Learned Court of Additional Session Judge Udalguri in Sessions Case number 32 of 2022, by which the applicant was sentenced to undergo RI for a period of 10 years with fine and default stipulation under Section 304, Part 2 of the IPC. This application will be considered after receipt of the trial court records. List this matter along with the criminal appeal on so and so date. Yes. Yes.
Maybe the Lordship. Lordship, I am for the respondent. Lordship, this is a criminal leave against the order of acquittal, Lordship, in an case, Lordship. So they have filed this criminal petition, Lordship, but on last occasion also they had not been, they had taken date, and this occasion they also.
Some AK Saxena appeared
Yes, Lordship.
on behalf of D-Day for the petitioner. Submit learned counsel for the petitioner. D-Day is out of station. They are not taking interest, right?
Yes, Lordship.
It is against acquittal, you said.
Against acquittal, Lordship. That is why it's a criminal petition, Lordship.
But then this cannot be dismissed for default or something. Let it be fixed again on a separate date.
Lordship.
Okay. None appears for the applicant on call. However, Mr. S. does.
K does, Lordship.
K does. Learned counsel appears for respondent number 2. Earlier they appeared. For the ends of justice, list this matter again on 24th of August, 2026. It will leave out likhiba, no? Leave why not? 37.
May please.
Yes. Again, you are there. What about the petitioner side?
But the petitioner is not, I am for respondent as legal counsel.
Petitioner is F. Hawk. F. Hawk is a advocate who regularly comes, I believe. A. Islam.
Delay condonation petition is there 216 days delay.
16 days.
216.
200.
His ground is that he was not aware about the judgment, but in fact, my lord, the judgment.
Acha, this is against acquittal or what?
No, it's a maintenance proceeding. It was
Maintenance.
revision. This is. His presence has been recorded in the judgment.
So you are for the
I'm for the
girl.
respondent, my lord.
Girl. And by the judgment, he was directed to pay how much maintenance?
Maintenance, my lord, 6,000 for the wife and 2,000. 4,000 for wife and 2,000 for child. Total 6,000.
He has challenged that.
He has challenged that.
2,000, 2,000.
4,000 plus 2,000.
4,000 to the wife.
To the wife and 2,000 for, yes, 4.
And 2 for the child. Very less. What
Very less and yes.
asset and liability was looked into
Well,
by the trial court, asset and family court matter?
no, it's
DV Act.
JMFC Hojai.
DV case.
Not DV 125 CRPC proceeding is there.
125.
125.
125 proceeding will go before the division bench.
I think not, no, it is revision against the maintenance.
Whatever it is, any order passed under chapter 9 of the Family Courts Act.
No, it is not family court, it is the judicial magistrate first class.
Acha, acha, 125
125
proceeding.
proceeding. So here his ground for condonation of delay is that he was not aware about it and he was not present. But
He was not aware about it. That was an ex parte.
his stand is that, but Lordship, may kindly have a look at page 10.
Let him come, let him come.
Well, then,
None
some other-
appears upon call for the petitioner. However, Mr. K.M. Halloy, legal aid counsel appears for respondent, sole respondent.
Sole respondent.
Sole respondent. List this matter again on 25th of August. 24th of August, Monday.
Mal, 24.
38, yes. Again, petitioner side is not there. What is happening today? Yeah? This is also some maintenance, no, na? No.
Lordship, it isn't. Also, appeal, it is
Asset Sigdar was
of
there.
delay matter. I am amicus.
Asset Sigdar. Asset Sigdar is that senior advocate or Asset Sigdar? Who was that Sigdar? Call after some time. You also, Mr. Ullah, if you can inform Mr. Sigdar.
Okay, well, I'll try.
Okay, come in the second half. The state appeal, state leave petition. No steps has been taken for service of notice.
I will take the steps.
Oh, steps received. Notice. Notice issued to respondent number 1 through APP. Huh? APP serving notice through APP. What happened? And notice upon respondent number 1 through APP. Yes. Yes, okay. But there is no report, right?
There's no report.
So, try to get the report. Heard Mr. B. Sharma, learned APP for the state. The office note reflects that steps have been issued, steps have been taken, and notice was issued through the office of the APP. But Mr. Sharma submits that he has no instructions as on date. As such, he is directed to get the instruction regarding service of notice upon respondent. Use this matter on. Then can you bring, list this matter on 19th of August. Dr. Dhrubajyoti Saikya, after some time, yeah. SS Botakur is there. Two. Yes.
Ma'am, please, Your Lordship.
Bail hearing.
Bail hearing.
TCR is there.
TCR is there, Lordship. Lordship, I'm paying for another date, Lordship. Any date, Lordship, Thursday or Friday.
Why do it today? Bail only. Have you seen the TCR, Mr. Sharma?
I'm also paying for an German Lordship.
Oh. Okay, tomorrow?
Let it.
Oh, tomorrow I might not have a single bench.
Then there.
Day after, oh, yeah. 12th I have a bench. Okay.
Right.
Mr. Ahmed, M. Ahmed, learned counsel for the petitioner. He prays that the matter be taken up on a later date. Prayer is allowed. List this matter on 12th of August, day after.
Kind of.
40 Q. Oh, yes. 41. No one appears. Again, second half. Second half, madam. 42 SP Chaudhary. Oh, same. 42 is also same. Yes. Which one is your matter? 42. Okay, at 2 o'clock. Yeah, so 2 o'clock. 43, Hassan I had seen, yes. Nazia Hassan. Mayor, 43.
Lordship.
Delay, leave.
Delay condonation, Lordship.
There are two, no, not two, right? Or no, only one I. Okay. How many days delay? Is it a POXO matter?
Lordship, 340 days as on 3rd of June.
POXO?
No, it's 376 IPC, Lordship.
376 IPC.
And
What are your grounds? 313 days delay.
14 days.
14.
Uh,
And you are the amicus, legal aid.
Legal aid counsel. It's a jail and so many procedures has been passed.
Normally, whenever a judgment is passed against a person, he should be immediately apprised by the jail authorities, right? If he is inside, if he is, right. So, jail authorities saying, informing him that he can file a jail appeal. That was not done or what? Why he did not come to know?
The grounds are explained in paragraph 3, Lordship.
Probably there is a respondent number 2.
Respond number 2, but since it is not a POXO matter,
Note.
not required. Where are your grounds? Paragraph 3, you said.
It's Lordship.
Delay is convict was informed about his right of appeal and order one either on was not what? The convict was informed about his right of appeal, either by appointing her own advocate or by way of jail appeal. Sent an application. But this information was very late, it seems.
I have annexed the
Where is that information? Where is that?
annexer number 1, Lordship.
Hmm.
There's a letter from the superintendent central jail, Silchar.
When was that letter issued?
10th of June.
10th of June. So not very long. The judgment was of 26/5.
But Lordship, in the middle, I have been allotted lots of bail matters. So I have to appear that. So that's my thing.
So the fault lies with you.
Yes.
Then what is the second annexure regarding appeal? That was given to you? No, from Salma Sultana to Honorable Secretary.
Yes, Lordship.
That was given in 27/6.
Yes, Lordship.
Then to Nazia Hassan, it was given in July 2025.
Yes, Lordship.
Your filing was very late. Okay, what to do? Okay, we will condone Mr. Sharma. I heard Miss Nazia Hassan, learned legal aid counsel appearing for the applicant, and Mr. B. Sharma, learned APP for the state. By this application filed under Section 5 of the Limitation Act, the applicant has prayed for condoning the delay of 314 days in preferring the connected appeal. The learned counsel appearing for the applicant had culled out, CULLED, had culled out the reasons for the delay in paragraph 3 of the interlocutory application. And it has been stated there that the convict was informed of his right to file an appeal before the High Court. And on being informed, the applicant had sent an application to the Registrar Gauhati High Court through the Superintendent of Central Jail on 10/6/2025. Full stop. The judgment against which the applicant has filed this instant application was passed on 25 was passed on what was the date of the judgment? (26/5/2025). Full stop. It was further stated that on 27/6/2025, the Secretary of District Legal Service Authority had addressed a letter to the Honorable Secretary, Gauhati High Court Legal Service Committee with the request that an appeal should be filed against the order convicting and sentencing the applicant before the High Court. And that thereafter, by letter dated 18/7/2025, the Legal Aid Council from the Gauhati High Court Legal Service Committee was appointed to file the criminal appeal against the conviction of the applicant. It is also stated that the Legal Aid Council, due to genuine reasons, took some extra time in drafting and the filing of the instant appeal was caused with the delay of 314 days. The reasons given in the said application is found satisfactory by this court. And as such, satisfactory by this court, full stop. Mr. B. Sharma, learned APP, in his usual fairness, had stated that let the appeal be heard on its merits. Accordingly, being satisfied with the grounds for delay, as well as looking into the merit of the case, this court finds it fit to condone the delay of 314 days in filing the connected appeal. As such, the IA criminal is disposed of by condoning the said delay. The registry is directed to register the criminal appeal, the connected criminal appeal, and list it for admission. Yes.
I for leave to file an appeal also.
Why is the condonation? Any delay?
It's not about condonation.
No.
It's file to leave. It's leave lordship to file.
No, leave will come later. Condonation will be first. Unless your delay is condoned, why should we look into the merit? Leave, we'll have to see the merit of the case,
Lordship.
whether you will be granted leave.
Lordship.
So any delay application?
No lordship. We just filed two applications. The IA for
Acha, there is no delay.
No delay lordship.
No delay.
No delay lordship.
Acha. Well, what is this item 40?
Item 40 lordship.
40.
Service complete lordship.
Okay, 540 is only for leave.
Leave lordship.
Acha, okay. I thought that there is also a delay.
No lordship.
Okay, service is awaited. What happened?
Service complete
Is it
lordship.
a POXO matter?
No, it's about NI case matter, negotiable instrument case matter. Acquittal was given.
Acha, show me your grounds for leave. Notice has been served.
The notice has been served. It has been already.
With a signature of Jan Dihingia.
Jan Dihingia lordship.
Along with the mobile number. Okay. So, okay, show me. But no appearance, right?
Yes, lordship. So kindly come to page number 4, para number 4, wherein I have defined a ground, mentioned a ground. That the acquittal is primarily founded on incorrect conclusion.
Which
that the
paragraph 4?
Paragraph 4, lordship.
Okay.
Failed to establish a legally enforceable debt, despite admitted issuance of sequence proven dishonor, section 118 and negotiable instrument, which were wrongly ignored and burden of proof was illegally shifted upon the applicant. Again, lordship, section 5. It is page number 5. To go scot-free despite owing a debt. There was a debt, lordship.
There was a debt, yes.
Debt, lordship.
But the trial court said that there is no legally enforceable debt.
There is no legally enforceable debt, lordship.
But the checks were issued by him.
Yes, lordship.
It was dishonored.
Lordship.
118, what is this presumption under 118A?
Lordship, the presumption under 118A is that
If
once
somebody
the check
issues a
is-
check,
Yes, Lordship, once the check is dishonored and it is presumed that
there
the
was a debt.
debt, Lordship.
What was the debt? 13 lakhs.
13 lakhs debt, Lordship. There's a connected criminal.
Where is the finding that no debt?
So kindly. So if you allow me, I
Was-
can praise this matter after at 2, Lordship, if you allow me.
It's already one. Okay. Place at 2.
Please, Lordship.
Isn't I know? Oh, leftovers are there, no? Okay. Okay, rest of the matter. You, Chaudhary, you have something?
Yes.
Which one? 44?
44 delay matter.
Delay. No, I have to see. Okay, at 2.
At 2, Lordship.
It's already one.
Lordship.
Acha, there was some mistake. Okay, tomorrow? Okay, day after tomorrow. Hmm. Hmm. 44 you are talking of? Acha. Hmm. Acha. POCSO? Okay, then. Let it be heard on merit, Mr. Kaushik. Okay. Heard Mr. Ayu Chaudhary, learned counsel for the learned legal aid counsel for the applicant. For the applicant and Mr. R.R. Kaushik, learned APP for the state. By this application filed under Section 5 of the Limitation Act 1963, the applicant has prayed for condoning the delay of 442 days in filing the connected criminal appeal under Section 415 within bracket 2 of the BNSS 2023. The learned counsel appearing for the applicant submits that the applicant petitioner was convicted by judgment and order dated 29/1/2025, passed by the learned sessions judge Kamrup Amingao in sessions case number 158 of 2018. Full stop. By the said judgment and order, the applicant was convicted under section 448, read with section 376 of the IPC, and was sentenced to undergo RI for a period of 6 months with fine and default stipulation under section 448 of the IPC. And the applicant was also sentenced to undergo RI for a period of 10 years with fine and default stipulation under section 376 of the IPC. The learned counsel for the petitioner submits that the delay was caused for genuine reasons, and the reasons has been called out, has been mentioned in paragraph 2, right? In paragraph 2, paragraph 4, in paragraph 4 of the said application. 4, 5, and 6. It is stated in the said paragraphs. It is pleaded by the applicant that the applicant had filed an application before the Superintendent General Central Jail for forwarding his case to the High Court on 26/3/2025, and that thereafter the petition was forwarded from the office of the Secretary District Legal Service Authority on 24/3/2026, and thereafter the learned counsel was engaged by the legal service authority to defend the cause of the applicant before the High Court. Full stop. The learned counsel further states that when the case was handed over to him, only the copy of the judgment was given, and that thereafter he had to take out all the necessary documents, and finally he got the criminal appeal ready on 15/6/2026, thereby causing a delay of 442 days. Full stop. Para. The reasons mentioned by the applicant in the said petition is satisfactory, and this court, therefore, deems it fit to condone the delay of 442 days in preferring the connected appeal. Mr. R.R. Kaushik, learned APP for the state, submits, in his usual fairness, submits that the case be heard on merits by this court. Finds it fit to condone the delay of so and so. Accordingly, the delay is condoned. The registry is directed to register the connected criminal appeal and list it for admission. Petition is disposed of. I is disposed of. Again, he's not there. Hmm? Yeah. Acha. Okay, none appears on call for the petitioner. However, Mr. Darakulla, learned counsel, appears for respondent number 2 as an amicus curiae. For the ends of justice, list this matter again on 18th of August, next Tuesday. List this matter on 21st of August. Yes, you are saying about something. Oh, you needed time to prepare. Okay, then what happened? This is for delay. Leave. Yes, leave. NI case. Oh, you were supposed to show me that. The finding of the court saying that there is no debt, enforceable debt. Where is that? 36. 36, yes. 30. 6. What? Discussion. Mm. 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 Of course, check numbers, it will be difficult for you to remember. But then other things could not recollect, okay? Dates on which he allegedly paid the advance amount, dates also you did not remember. And then of the alleged, recollect the date or contents of the alleged FIR or complaint. No power of attorney executed a file. However, in this also admitted that boundary schedule was entirely blank. He had not mentioned or in the affidavit. Mm. Mm.
I cannot recollect the date of notarized agreement for say I have mentioned. Hello. I have mentioned about filing conference the date on which I can notarized. I cannot say the date. These are the that a unique person will ask to do.
And what about his examination chief? He had said, just read it out once. Affidavits on evidence, yes. Acha. Acha, have you annexed the CR complaint here? Acha, where is that? Main case. In the IA, you have only given the judgment. It's okay. It's okay. Heard, Mr. U.S. Bora, learned counsel for the petitioner, and Miss. He is the state is a party, not a party. Acha, okay. Now, by this application, filed under section 419, within bracket 4 of BNSS 2023, the applicant has prayed for leave to file an appeal against the judgment and order dated 28/11/2025, passed by the learned Chief Judicial Magistrate Sibsagar in NI case number 5 of 2022. Full stop. By the said judgment and order, the respondent was acquitted of the offence under section 138 of the Negotiable Instrument Act 1881. The learned counsel for the petitioner submits that the learned court of Chief Judicial Magistrate Sibsagar had not considered the case in true perspective and by taking into account certain statements made in the cross-examination of the complainant, had acquitted the respondent. Full stop. The learned counsel submits that the that the petitioner, that the applicant had given an amount of rupees total submits that the applicant had given 2 checks, right? Checks or what? How did you pay? Had paid to the respondent, had issued 2 checks in favor of the respondent and paid rupees 30 lakhs in total to him. 13 or 30? 13, huh? 30. 13 lakhs. And when he asks for the money back, the respondent had given a check which got dishonored on its presentation before the bank. Full stop. The applicant, as such, issued a notice to the respondent for paying the said amount. And the respondent had replied. No reply. To which the respondent had not replied. Full stop. The learned counsel and that not replied, and that a case was instituted thereafter. Full stop. He further submits that the learned trial court had based its findings only on the ground that the complainant could not establish the legally enforceable debt with regard to enforceable debt, that is, no, with regard to the respondent. Full stop. He further submits that during the cross-examination, the applicant had stated that he did not remember the check numbers, as well as he did not remember the date on which the payment was made, as well as the date and contents of the FIR. And on the said statements made, the learned trial court had returned the finding that there was no enforceable debt against the respondent. However, he submits that admittedly money was given and the same was repaid by issuing the check by the respondent, which got dishonored. He also submits that had there been no enforceable debt, there was no occasion on the part of the respondent to issue the check to the petitioner. He therefore submits that the matter be heard on merit by this court. On consideration of the submissions made by the counsel, it is seen by this court that said money was taken by the respondent to pay for some land, to make payment pursuant to an agreement of sale of a property, and that the petitioner had given two numbers of checks amounting to rupees 8 lakhs once, and what did you say? Amounting to rupees 8 lakh by one check and an amount of rupees 5 lakhs by another check. No. This is accused who had given. How did you give the money? Oh no. How did the applicant give money to the accused? Oh, acha, you did not pay anything. Your land, you had sold it to the accused. And he was supposed to pay the money. While dictating, I had not said that. You should have pointed out. I thought you had paid money for some purpose and then he returned with a check. Okay, let me read it myself. It will a last or earlier one also I'll have to correct. It will detail that this court finds the case upon consideration process. This is accused had given. It's 8 lakh and 5 lakhs. I was asking you how the petitioner had given money, but then there is no question of petitioner giving money. Petitioner had purchased a land. That you should have told in the beginning, you did not. And while dictating also, you must not have followed. Acha, upon consideration. That, but that, that the petitioner, being the owner, petitioner is the owner of what? Proprietors. The petitioner, being one of the proprietor of Pragati Hospital and Research Center, intended to purchase a land from the petitioner, from the respondent, who had shown him and the co-proprietor a vacant plot of land, saying that he wishes to sell to them. And pursuant to the same, an agreement was entered into between the parties. It's okay, it's okay. Let me read. You don't have to say. You didn't say the actual facts. By entering a deed of agreement, right? Of for sale on 25/1/2020. And that on the same day, the petitioners had paid to the respondent a sum of rupees 5 lakhs. And thereafter, another 2 checks of rupees 4 lakhs and 8 lakhs in total. Full stop. It is also stated, it is also noticed that respondent, this is applicant's acquittal, right? Respondent had encashed the check and that he had taken a total amount of 13 lakhs as advance through 3 checks from the petitioner. And that thereafter, the petitioner found out that the land does not belong to the accused person and that the respondent had lied to them about the said land. And then the petitioner asked the accused person to return their money. And that the respondent returned the money by way of check, which were in 2 numbers for rupees 8 lakhs and for rupees 5 lakhs. However, it is seen that the check got dishonored and the subsequent proceedings started. However, the learned trial court, on certain statements made by the petitioner during his cross-examination, had held that there was no legally enforceable debt against the respondent. Full stop. By looking at the facts, this court deems it fit that leave be granted to the petitioner to challenge the said order of acquittal passed by the Chief Judicial Magistrate Sibsagar on 28/11/2025. Accordingly, leave is granted and the connected criminal appeal be numbered by the registry. Petition is disposed of. Forty-one is also yours? No. Yes, Mr. Mondal or Islam Punna also. This is I what? I for bail, suspension of sentence. I POXO. Then so we'll have to appoint somebody. What about the main criminal appeal jail? You are the legal aid counsel. This is not from jail. This is this a criminal appeal from jail? I mean 389, whether the convict has filed it through jail or it's a regular appeal. But then it's jail appeal. It's criminal appeal jail. The convicts who cannot afford a advocate, they sent it through the superintendent of police to file an appeal against the judgment before the High Court. So what, is this that type or it's a regular appeal? Why is it registered as jail appeal then? You are not aware. You have not seen the cause list. NCR was called and the notice had gone to the respondent. So are you sure it has to be renumbered? It has to be renumbered. Criminal appeal ceded causeless. It is criminal appeal jail 67. You had not pointed out in the registry. You should have. Why was it registered as jail? In the letter from the convict. I'll have to find out all this. You should have found out. Hi, is Mr. Kaushik? But initially, in the notice means this is a notice to the public prosecutor about serving the copy. Their jail appeal is not reflected. It's a regular appeal. Later on, why did it become jail? Wakalatnama also shows it's a criminal appeal, regular. What yes? You should have pointed out to the registry. Later on, it was all made J by hand. Who has made this by hand? You check the file. Let me know. Check korbo, I know. Check the file. Yes. It was, just see, it was all handwritten. J is handwritten later on. Wakalatnama does not. No, there is no letter. There is a wakalatnama. It was wrongly. Let Mr. Sharma see. You said for a while. Mr. Boyddo is there. Mr. A.M. Bora is there or what in this case? So I cannot take it up. This is Jahangir Alam. This is D.K. Boyddo is there. Huh? Are you sure Mr. A.M. Bora is there? Then I cannot take it up. Let me see the wakalatnama. Oh, A.M. Bora's name is not there. D.K. Boyddo and P. Mujumdar. So, what are your instructions? Where? His name I don't see anywhere. D.K. Boyddo's name is there. And in Wakalatnama also A.M. Bora's name is not there. Heard, Mr. B. B. Majumdar, learned counsel appearing for the appellant. Mr. Majumdar submits that senior advocate, Mr. A.M. Bora, will appear in the case. As such, list this matter before any other bench, not with me. Huh? Senior advocate, huh? Mr. A.M. Bora. Yes, item. Yes, 10, no one is there. ASIK is not there. Some criminal appeal ki ase nato. Yeah, it was, yeah. Enactor hoga. None appears on call both from for the petitioner as well as the respondent. Oh, however, respondent number 2, dear. However, Mr. R.R. Kaushik appears for respondent number 1. For the ends of justice, list this matter again on 28th of August. Aru, hold on. 13. Counsels are not here. N. Borua. AJ Pathak. None appears on call for None appears on call for both the appellant as well as respondent number 1. However, Mr. R.R. Kaushik appears for respondent number 2, that is the state of Assam. For the ends of justice, list this matter again on 24th of August. H. Ali. H. Ali is that advocate who got bail in the morning. I. Hazarika. I. Hazarika comes, right, Mr. Kaushik? I. Hazarika, he comes to the court. I. Hazarika, whose wife expired. Right. But he is not there today. Okay. None appears on call both for the petitioner as well as respondent, private respondent number 1. Respondent goes a private respondent. However, Mr. R.R. Kaushik, learned APP, represents respondent number 2. For the ends of justice, list this matter on 25th of August. Mr. Chaudhary, you have something?
41.
41. Yes, 41 is Mr. Mondal. Oh, yes. So, mm. 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 So, they has to correct the CIS system also. Okay. Heard Mr. M.A. Mondal, learned counsel appearing for the appellant, and Mr. R.R. Kaushik, learned APP for the state. You also bring the information. This is POXO, right? Mr. Mondal, learned counsel for the appellant, submits that the present appeal is not filed from jail under section. Oh, remember, even the CIP is going to give out. CIP. Jail under section 3 and something. (383) of CRPC or oh, this now it is what? 383 is 424. 424 of BNSS. কি হলো কি হলো আচ্ছা মন্ডাল নকব it is noticed so and so it is noticed it is noticed that the present appeal না আকল লিখা ভালকে it is noticed that the present appeal has been registered as criminal appeal jail 67 of 2024. But when the matter was taken up and it was inquired, the Learned Counsel for the appellant submits that the present appeal is a regular appeal. Regular appeal. Filed under section 415 of the BNSS 2023 against the conviction and sentence order by judgment and against the conviction against the judgment and order dated 12/6/2024 passed by the Learned Special Judge Udalguri in special POCSO case number 6 of 2021. Full stop. It is further seen in the copy of the Wakalat Nama that initially it was criminal appeal number criminal appeal number 67 of 2024, and the Learned Counsel has signed in the said Wakalat Nama. But later on, it is noticed that the said appeal got registered as jail appeal. As such, it is the registry is directed to find out the proper nomenclature of the said appeal and make correction in the CIS system. CIS is a S is system or what? CIS, not system, no? I think S is system. In the CIS. Further, it is seen that notice on respondent number 1 has been issued through the office of the learned PP, but there is no office note showing the service thereof. As such, Mr. R.R. Kaushik is directed to find out the status of service of notice upon this private respondent. LCR, isn't it? LCR. The trial court record has been received. List this matter on 24th of August 2026. Right. What else? IA is there. IA is for suspension. But then there is no IA notice given as well. IA there is no notice. Okay, IA likha. This is an application for suspension of sentence imposed upon the applicant by judgment and order dated 12/6/2024, passed by the Learned Special Judge Udalguri in special POCSO case number 6 of 2021. Full stop. By the said judgment, by the said judgment and order, the applicant was convicted under section 4 of the POCSO Act as well as under section 506 of the IPC. And he was sentenced to undergo RI for a period of 10 years with fine and default stipulation under section 4 of the POCSO Act. Full stop. The appellant was also sentenced to undergo RI for a period of 1 year under section 506 of the IPC. And the sentences were directed to run concurrently. Issue notice. Applicant to take steps for service of notice upon respondent number 2 by following the practice directions, as this matter relates to an offense punishable under the POCSO Act. Records have already been received. List this matter on what date I said? 24th. Acha, get the instruction now, Kaushik. Otherwise, we can take up that once that service is complete. It will last me. It will last me. I'll do that. Okay, Mr. Chaudhary, what happened here? Hmm. Acha, okay.
Distribution the evidence of this. So the girl, claims to be the victim of the.
Acha, wait. I'll take, there are two IAs, you said, one is for additional evidence and the other for suspension. TCR is not here. Is it a POXO matter? This is conviction under 376. Okay. That is required. Otherwise, in the appeal that I can see an order. Hmm. But then they'll have to file application for objection. They are mandated. But then some opportunity. We will take it up next week. Okay, then do I fine. I'm talking of next week only. You file an objection. He's saying he's 65 years old. Okay, you write in the IA. Write in the IA 564. This is an heard Mr. S.P. Chaudhary, learned counsel for the petitioner, and Mr. R.R. Kaushik, learned APP for for the state. By this application, filed under section 430 of BNSS 2023, the applicant has prayed for suspension of the sentence imposed upon him by judgment and order dated 23/3/2006, passed by the Court of Session Judge Udalguri, Assam, in sessions within bracket Roman 2, Dangor, case number 85 of 2023, full stop. By the said judgment and order, the appellant was convicted under section 376 IPC and was sentenced to undergo imprisonment for 10 years with fine and default stipulation. Mr. R.R. Kaushik, learned APP, prays for some time to file the written objection as mandated under section 430. 430 of the 430, it is given like 390. 430. Oh, yes. Shall give opportunity for showing cause in writing against 430 of the BNSS 2023. List this matter on what date can you file? Next week. Okay. Next week, Thursday. List it on 28th of August. 20, right? 20. In the appeal, you write? Heard Mr. S.P. Chaudhary and so and so. It is seen in the office note that requisition has been sent for receiving the TCR, but the same has not been received. As such, the registry is directed to send a reminder for receipt of the trial court records. List this matter on the same day, Where is the other IA? That we will have to consider after seeing the evidence again. I've given the right thing, I think it okay. 564. 564 is suspension. The file that I'm carrying, 564, and it is praying for suspension and it is other one to solve. This is for additional evidence. 576. DNA profiling test.
Yes.
Why? The son with the father or what? DNA? Blood?
But it's saying, child is because of the
Ah.
husband,
Ah.
you are not like a
No, no, not required. Because you see, in a criminal case, this DNA, even if it comes positive, it will not clinch the issue. It will be only a corroborative evidence. So, DNA profiling is not required.
child.
Doesn't matter. Her evidence, this is 376. Her evidence before all the authorities will be seen. If it is consistent, good. If it is not consistent, we will see some corroborations. But you see, the child can be of someone else. But the offense of rape will still be established against him.
It can be a, that is that she states anomalies in the case because the incident and because the statement of the informant is that 5 months back the incident had occurred.
Huh.
And subsequently that the victim girl is saying that she is staying in the particular place only. So the anomalies are very much apparent.
And then it will be considered that the child is not of the appellants. But then that will not absolve you from the criminality. So as such, I don't think so this application will be valid. Not required. You see Supreme Court cases. You mean to say that the child, when the child was born, it could not have established, it cannot establish that it is the result of the rape committed by the appellant on the victim.
I have done this application establish the veracity of statement of the informant and the victim girl. Because victim girl and the informant is immediately saying this child is born because of the rape apparent. So if we can decide that for this particular child by your DNA, then it will come in the way.
No, it's okay. Whatever FIR says doesn't matter. We'll have to see whether rape is committed or not.
Exactly, Lordship. They are saying this child is because of the rape committed by the appellant.
It cannot be one incidence only of rape. There can be, okay, she must have been subjected to others also. But
there is no statement there because this is specific statement on the part of the victim as well as the informant. This child is born because of the rape committed by the.
it's okay, even if it comes out to be true, okay. Even if it comes out to be false, that child was not as a result of the rape committed by so and so. But then the rape which can be of various, on various dates, that still can be established. The child may not be the appellants. Veracity of the statement we will see from comparing her statements. But no, see, DNA profiling should not be done on a very routine basis. Only in exceptional cases.
I will please certain judgment.
Okay. ठीक है. I criminal 576 or लिखा heard Mr. So and so and so and so. This is an application filed under section 391, read with section 528 of BNSS, by which the applicant has prayed for taking additional evidence in the appeal by way of DNA profiling test. The learned counsel for the petition for the applicant submits that the allegation made by the informant that the child given birth by the victim was of the appellant. And, or in other words, the child was born in pursuant to the rape incident committed by the appellant on the victim. However, it is also a subtle position of law that even if positive results come, or even if negative results come, showing that appellant has not fathered the child, the same will be considered only as a corroborative evidence. However, Mr. Chaudhary prays for some time so that he can bring and place certain decisions on that aspect. List this matter along with the other appeal. একেলগে দি দিব for consideration. Yes. Any counsel for 17? No? 17 who appears? Dilip Day. Dilip Day. There was one more Day who used to come regularly. He's not Dilip Day, right? BR Day, I think. No, none appears on call for the petitioner. Neither. Oh no, notice have not gone. But petitioner, however, Mr. R. Kaushik appears for for the state of Assam. List this matter again on 27th of August. Will it be too late? 34. Huh? 34 is a leave appeal by Mr. Keal. What happened? Union of India, perhaps he is no longer there. Actually, the steps were not taken. There was a Lawajima report showing that the petitioner had went unrepresented, and the direction was given for them to take steps. They did not take steps, and it was further directed that if they fail to take steps within a 1 week, then it will be placed before this court. In fact, it was placed before this court, but then no one appears. None had appeared on 6/2. Mr. Keal had appeared in November 24. This is a leave petition. 34. Criminal appeal. I don't think so. Criminal appeal cannot be dismissed for default, no. Somebody has to be appointed. Okay, you inform them. Huh? None appears on call for the applicant. An office note dated 17/6/2026 is sealed, wherein it showed that case was taken up by Lawajima court, and before the said court also, none had appeared for the petitioner. Maybe DRI, right? See. This is NCB case. So DRI. Represented by Narcotics Control Bureau. One boy appeared today for DRI. New boy. I have not seen him earlier. Tell him. Okay. Kulno. Lawajima court on that day also. Yes. It is further reflected that the instant case was placed before the Lawajima court on an earlier occasion too, and the petitioner was directed to take fresh steps, but the petitioner did not. And before the Lawajima court on the next occasion, the petitioner did not appear. Petitioner did not appear. As such, there is a direction from the Lawajima court to the petitioner to take steps, but they had not taken, and the matter is placed before this court. However, for the ends of justice, the learned counsel appearing for the appellant, that is for the NCB, be informed by the registry, and thereafter necessary orders would be passed. List this matter on a date to be fixed by the registry. Right. Over, Nikki? Okay. So I finished because I had a division bench today that got cancelled. Otherwise, matters will not be so less before me. Okay. Chalo.